Hello, everyone, and welcome to another edition of Uncivil Law. I am your host, Blackleaf. Hope you're having a great day as always, and we are here with yet another edition of Supreme Court Acts. So I'm very excited about that. We are here with one of the most notable decisions for this term. It is a decision. Well, it's not a decision yet, but presumably will be. It's a case dealing with abortion out of Louisiana. This is entitled June Medical Services LLC versus Russo. So I want to give you a little bit of background on this case, a little bit of background on the law, so that you can understand the legal posture of where we are, and so that'll be a little bit more understandable. So let's begin with the first major abortion case that everyone knows, Roe versus Wade. So Roe versus Wade, at the time before that case, I believe 4 states allowed for abortion, if memory serves correctly. And of course, Roe versus Wade, I believe, was out of Texas, and said that you could have abortion on a different rules on a trimester-based system. So under Roe versus Wade, the rule was for the first trimester, you could essentially have abortions without restriction. During the second trimester, you could have abortions with restrictions. And during the third trimester, abortions could be banned by the government, with the exception of life threat to the mother. So if there was a life threat to the mother, you could have abortion on that. But that was the trimester-based system of Roe versus Wade. Then in the 1980s, we had the follow-on case, then called Casey versus Planned Parenthood, which is the big case that currently is interpreting abortion law. Casey, in large parts, substantially modified Roe, not as well known, but it is the dominant case, I think that's fair to say at this point. And what Casey versus Planned Parenthood did essentially was abandon the trimester-based system. It instead said that the line of demarcation was viability of the fetus. It left it open as to what that is on purpose, because it was recognizing that the trimester-based system was running into medical reality. As medicine was getting better and better and viability was changing, the system was sort of on collision course with itself. So basically they said, okay, the new line is viability. Before viability, you can do it with restrictions as long as they are not unduly burdensome, undue burden, to use the exact phrasing. We're going to talk a lot about that today, I'm sure. And then after viability, the government could presumably again ban it, again with the exception of life threat to the mother. So that's the current kind of state of the law as it exists right now in federal law system. Then today, we're going to be talking quite a bit about a case called Whole Woman Health versus Hellerstedt, which was decided 4 years ago. So in Casey versus Planned Parenthood, I said that phrase undue burden. That's the phrase that's all the other abortion cases that have happened since, well, not all, but pretty much all the cases on abortion that have happened since Casey versus Planned Parenthood have been interpreting in some way or another what undue burden is, what it means, what the limits of that are. So if you ask me, what is an undue burden? I'm going to say, here's 30 years of case law that decides that, because that is exactly what this case is here to decide, as pretty much every other case has been for the last 30 years, trying to figure out what undue burden means. But in the case called Whole Woman's Health versus Hellerstedt, I believe again was Texas, but I could be mistaken. There was a state that put in place a rule that in order to be an abortion provider, you had to have, and I believe it was targeted at high risk abortions or late term abortions in particular. So it was a law targeted at people who were doing late term abortions, as memory serves, and these people had to have admissions privileges at a local hospital. The law in the relevant state at the time said that in order to get these admission privileges, you had to have a certain number of patients who would come through the hospital in, say, an annual time period. So it wasn't available to every qualified doctor. It was only available to doctors who would have so many admissions per year. And because of the nature of the kinds of abortions these doctors were performing, they were so far and few between, and the number of complications that would require admission to a hospital were so few that they would never hit that threshold. So as a practical matter, they couldn't get the admissions rights to the hospital, because either as a function of the relevant state law or as a function of the medical criteria or whatever, they had to have a certain minimum number of admissions, and they couldn't get that because of the nature of their practice. They wouldn't be admitting patients on a regular enough basis in order to get admission privileges, and therefore, because they couldn't get admission privileges, they wouldn't be able to perform the kind of abortions in question. So that was kind of the deal there. So that brings us to the current issue, where we're out of Louisiana, where the Louisiana courts or legislature, the Louisiana legislature has put in place a law that again requires physicians to obtain admission privileges at hospitals in order to perform certain kinds of abortions. And so that is the case at the issue here. So there's a factual dispute. There's not. Let me say this: the factual predicate is different here than it was in Whole Women Health. In Whole Women Health, the precedential case, the factual predicate was it was very, very hard to impossible for these physicians to get the admissions privileges. Therefore, it was very, very hard to impossible for them to perform the abortions in questions, and that was the undue burden, right? It was that factual predicate. The factual predicate here, as I understand it, is different, at least according to the briefing. As I understand it, according to the briefing, the physicians are able to get these admission privileges on a much easier basis. Now, to how easy it is of course going to be an issue as to whether or not it's undue burden. If something's available for like any qualified physician, then it's probably not an undue burden. And all the way to where it was basically impossible to get, it would be an undue burden. So this case could very much turn on a fact-specific predicate. This case could turn on the factual difference, where in the Texas case, it was impossible to get it, but in the Louisiana case, maybe it's easy enough to get it, and so it's not an undue burden. So it doesn't necessarily have to overrule or modify the decision on the book from 4 years ago. This case could split on the factual difference. So the factual difference may be enough for the court to say, this is okay in this circumstance, and it wasn't okay in the Texas circumstance, and for those decisions both to live in the same universe at the same time. So that's one possible outcome. Another possible outcome is that there is a potential standing issue. We've seen quite a few of these in cases we've covered this term, where the people that are bringing this complaint, June Medical Services, may not have standing because they are not being hurt by it. They are not the doctor, they're not the patient, they're a collective organization trying to adopt the rights of their members. And of course, we've seen that from time to time in famous cases where NAACP, for example, has filed suit on behalf of its members, ACLU has filed suit on behalf of its members, NRA has filed suit on behalf of its members. But the ability of an organization to represent its members in court is very, very tricky. It can get, again, very fact-specific into the nature of the disputes and very things here. So just because organizations in the past have been able to represent their members doesn't necessarily mean that they can here. And it could turn on some fairly interesting minutia with the nature of the relationships and questions. So there's a standing question here, and there's always this kind of latent standing question when you have organizations not for themselves, not the NRA suing or the ACLU because they themselves are being hurt as an organization, but because their members are being hurt. So there's a standing issue here. So this case could be punted on the standing issue to avoid the whole problem. And then, of course, there are the more unlikely scenarios where the court would overrule the precedent. I don't think it's required. Based on what I see here, I don't think it's necessary to do that. I think they can avoid that issue. I don't think it's necessary to overrule Whole Woman Health, and there isn't any of the traditional markers that I've seen that would cause it to be overruled for anything, but there is There's always that possibility, which is the more remote possibility. But we cannot proceed further without talking about the wonderful comments of Chuck Schumer as he, decided to open his mouth recently on this issue about Gorsuch and Kavanaugh. So I'm gonna see if I can find his quote on YouTube real fast and pull that up on that, because it was an interesting moment in time. So I'm just gonna pull that up real quick. Inside the walls of the... Hold on, I want to get this full screen, so I'm just trying to see what where our friend Mr. Schumer decided to open his mouth. So we're going to listen to just a moment from this, because he decided to open his mouth. So we'll just listen to this. Hold on. Sorry, I need to change the audio there because I know it's not playing. Give me a second. If I change it to this, and that should work, and mute myself, and let's give this one.
The first major abortion right cases since Justices Kavanaugh and Justices Gorsuch came to the bench. We know what's at stake. Over the last 3 years, women's reproductive rights have come under attack in a way we haven't seen in modern history. From Louisiana to Missouri to Texas, Republican legislatures are waging a war on women, all women. And they're taking away fundamental rights. I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind, and you will pay the price. You won't know what hit you if you go forward with these awful decisions. The bottom line is very simple. We will stand with the American people. We will stand with American women. We will tell President Trump and Senate Republicans who have stacked the court with right-wing ideologues that you're going to be gone in November, and you will never be able to do what you're trying to do now, ever again. You hear that over there on the far right? You're gone in November. We are here to send these folks a message, not on our watch. So let me ask you, my friends, are we going to let Republicans undo a woman's right to choose? Are we going to stay quiet as they try to turn back the clock? Are we going to give up or waver when things get tough? No, we're going to stand together in one voice and take a stand on behalf of women and families throughout the country. We're going to stand against all these attempts to restrict a woman's right to choose, and we will win.
All right. Well, that was a lot. Thanks, Chuck. That was great. Yeah, you will pay the price. I also like how you have unleashed the whirlwind about a case that they haven't decided yet. How do you release the whirlwind on a case you haven't decided? As and you will pay the price and all this stuff. So really, really great rhetoric there from Chuck Schumer there. It's like, okay, well, good times. Yeah, good times. So, with all that wonderful predicate out of the way, let me read the facts of the case and the issue, and then we will get into the oral argument, which is what you guys came for. We had a lot of introduction for this case because I wanted to set up the law, set up the posture so that you knew a little bit about how we got here, talk a little bit about Roe, talk about Planned Parenthood, talk about this case, Whole Woman's Health. So I had to talk a little bit about 3 separate cases so that you would all have enough legal background to understand the framework that we're trying to work with, right? So that took a little time. And then we had to listen to Schumer open his mouth. But here are the facts of this particular case. In June of 2014, Louisiana passed Act 620, which required that every physician who performs or induces an abortion shall have administrative privileges at a hospital that is not located further than 30 miles from the location at which the abortion is performed or induced. Several abortion clinics and doctors challenged Act 620, and while that challenge was pending in the district court, the United States court struck down a nearly identical Texas law in Whole Woman Health versus Hellerstedt, which is what we talked before. So there's these twin cases that were like happening at the same time, and while this case in Louisiana was percolating, the other case was decided, right? So, excuse me. So in Hellerstedt, the court found that the Texas law imposed the undue burden, that's the phrase we've been trying to interpret for 30 years, imposed an undue burden on a woman's right to have an abortion while bringing about no health-related benefit and serving no related credential function. The district court, hearing the challenge to this law, accordingly declared the law facially invalid and permanently enjoined its enforcement, based at least in part on the Supreme Court. The district court made detailed findings of fact and determined that administrative privileges do not serve any relevant credentialing function, and physicians are sometimes denied privileges for reasons unrelated to competency. The district court further determined the law would drastically burden the woman's right to choose abortions. A panel of the U.S. Court of Appeals for the Fifth Circuit, my new home, the panel majority reviewing the evidence de novo and concluded the district court erred by overlooking remarkable differences in the facts of this case and the underlying case. And I talked a little bit about some of those facts, right? The ease of the credentialing and so forth and so on. So the court said, no, you've overlooked some things, so try again. The court concluded that no clinics will be likely forced to close on the account of the act, and thus the law would not impose an undue burden on the woman's right to choose. A divided Fifth Circuit denied the petition for en banc. So the district court said this is unconstitutional because these are the same case. The Court of Appeals said it's not unconstitutional because it's not the same case. So again, as I was saying earlier, this may very well turn on whether or not it's the same case or not. How similar, how comparable is it to the Texas case? Is it factually splittable? Can you split one versus the other? My understanding, and I'm by no means an expert here on this because I've read a little bit but not a huge amount, but my understanding is, yes, it can be split. And so if I had to guess going in, I would guess that it is going to be split by the Supreme Court on the facts. So I think that the most likely outcomes are either that they're going to uphold the statute, or they're going to punt it on standing, but I think the standing thing is less likely. I think there's enough standing here in my opinion, although it is a closer question. And I think if they get to the merits, that they're going to uphold the Louisiana law. And I'm not really sure on the vote on that issue because I'm not even sure that the left might necessarily want to stick their nose out on this particular one. So we'll have to see. But here is the question presented. The question presented is, does the decision by the United States Court of Appeals for the Fifth Circuit below, upholding Louisiana's law requiring physicians who perform abortions to have admitting privileges at a local hospital, conflict with this court's binding precedent in Whole Woman's Health versus Hellerstedt? So if anyone else comes in at this point and says, what is this case about? I'm not going to answer that. I've given enough background. You in the chat can take care of it. But, if they missed the introduction, we've been talking for 19 minutes just to get this set up because I had to go through a fair amount to get it set up. So I'm not pausing the stream to talk about it. So if anyone asks, tell them you guys can figure it out and referee that, but we are not doing that anymore. So we are going to start with oral arguments. So I need to, let's see. Now I need to figure out how to make this work for me. Let me change my output so I can hear it in my ear. So I'll change it from here to here. And then I need to change the audio from here to, here, properties. Change it from here to here. So hopefully there will be no feedback. Let's give it a shot.
We'll hear argument this morning, case 18-1323, June Medical Services versus Russo, and the cross petition 18-1460, Russo versus June Medical Services. Ms. Rinkleman?
Mr. Chief Justice, and may it please the court, this case is about respect for the court's precedent. Just 4 years ago, the court held in Whole Women's Health that the Texas admitting privileges law imposed an undue burden on women seeking abortions. The Louisiana law at issue here, Act 620, is identical to the Texas law and was expressly modeled on it. After a trial, the district court ruled Act 620 unconstitutional, finding no material differences between this case and Whole Women's Health. On burdens, it found that Act 620 would leave Louisiana with just one clinic and one doctor providing abortions. At the same time, it found that Act 620 would do nothing for women's health. In reversing the district court's decision, the Fifth Circuit committed two fundamental errors. First, it usurped the role of the district court and disregarded nearly all of its factual findings. Second, the Fifth Circuit accepted legal arguments that this court rejected 4 years ago. Nothing, however, has changed that would justify such a legal about-face. In fact, even more medical organizations have joined the AMA and ACOG to say that admitting privileges impose barriers to abortion with no benefit to patients, and that this impact is not state-dependent. Finally, the state's 11th hour objection to third-party standing runs up against still more binding precedent. The court squarely held in Craig versus Boren that such objections are waivable, and the state deliberately and strategically waived the issue in the district court. And even if the state could get past waiver, denying standing here would contradict decades of this court's precedent in numerous areas of the law. In short, petitioners have third-party standing, especially because Act 620 restricts abortion by regulating them rather than their patients.
Would you have done anything different if the third-party standing had been timely raised?
Your Honor, we certainly could have.
So I was talking about this a little bit in the introduction, but when they're talking about third-party standing, they're talking about standing on behalf of other people, right? So it's not you who's suing, you're suing on behalf of someone else. And so I was talking about this a bit in terms of organizational standard, when organizations are trying to sue to protect the rights of their members, for example. So we talked a little bit about NAACP, ACLU, NRA as examples of groups who have done this kind of thing. And so that would be a third-party standing. It's not it wouldn't be ACLU suing because ACLU themselves are being hurt. It'd be ACLU suing because their members are being hurt. And as I said, the third-party standing doctrine can get very complex. So, you know, if it turns on that, we are probably outside of my area of expertise because it can get really minutiae-esque. And so if it really turns on like third-party standing issues, is probably outside my ability to predict, but we'll see what happens, I suppose.
Submitted additional evidence in the court, but we believe that the evidence that is already there is sufficient to find third-party standing. This court has squarely found third-party standing in at least 4 abortion cases that are on point, as well.
And Jan is right. Jan is right. One of our only rules in this chat is you can't call each other names. You can disagree with each other, don't insult each other, okay? That's really one of my only rules. So no name calling, no like using slurs against each other in terms of like calling people stupid or something. You want to have a chat, fine. But, you know, be nice. That's really one of my only rules. Be nice.
There's a number of other cases such as Meyer, Craig, Carey, and the court's cases have been consistent in saying that a plaintiff who is directly regulated by a law has third-party standing.
Would you agree with the general proposition that a party should not be able to sue ostensibly to protect the rights of other people if there is a real conflict of interest between the party who is suing and those whose rights the party claims to be attempting to defend?
No, Your Honor, not if that party is directly regulated by the law in question. And in fact, this court has allowed third-party standing in cases where the state argued that the third parties were protected by the law and in a sense protected from the plaintiff.
Really, that's amazing. You think that if the plaintiff actually has interests that are directly contrary to those of those individuals on whose behalf the plaintiff is claiming to sue, nevertheless, that plaintiff can have standing?
If the plaintiff is directly regulated by the law, this court has allowed an attorney to bring third-party claims against a statute that capped attorney's fees in favor of clients.
Well, that's amazing. Suppose, I know you think that the admitting privileges requirement serves no safety purpose, but suppose that the regulation that was being challenged was one that a lot of people might think really did serve a safety purpose. Let's say we're in a state where physician's assistants can perform abortions, and an abortion clinic wants to challenge the training requirements for physician's assistants. It just thinks those are too onerous and there's no justification for them. Now, if they're wrong about that, it implicates the interests of the women who may want to get an abortion. But you would say the clinic nevertheless can sue on behalf of those women?
This court has squarely held in many cases that a plaintiff directly regulated by the law can sue, and those cases make sense for at least two reasons, Your Honor. First, because a plaintiff should not be subject to severe penalties under an unconstitutional rule. And second, if the plaintiff is the one directly regulated, then it makes sense that they are the appropriate plaintiff, and that's clearly true.
That sounds like direct standing, not third-party standing. But in this case, is there anything like the conflict that Justice Alito had mentioned? Is there a conflict?
No, Your Honor. There is not even a plausible conflict in this case because this court already held that admitting privileges serve no medical benefit. And the district court here, after a trial, specifically found that this law would serve no benefit and, in fact, would harm the health of women in Louisiana.
But, your argument is using the merits to support standing. There's a serious problem with that.
No, Your Honor. I believe it's the state that's collapsing standing and merits. And again, this court has allowed third-party standing in cases where one could argue that the state law in question was protecting third parties from the plaintiffs. In addition to triplet, that was the issue in Craig versus Boren. The law there was a state law in Oklahoma, and the state claimed that it was designed to protect young men from buying beer in order to make sure that they were safe and didn't get into traffic accidents.
Counsel, I'm just wondering, are these doctors in any different position than potential plaintiffs, women, who feel burdened by this law?
No, Your Honor. And in fact, the state has not pointed to a single thing that would have been different if one woman had been joined in this lawsuit. To the contrary, the issues that the state says are the key issues in this case, whether this law serves health and safety benefits and how difficult it is for physicians to obtain privileges, are issues that the physicians are particularly well suited to litigate. And again, this is a law.
So the point is you have standing on behalf of those women who feel burdened.
Yes, Your Honor.
To the extent.
Yeah, I think this is one of the reasons I tend to think that there is a standing issue, because I think the doctors themselves have a standing issue in being able to perform their trade. They have a issue in being able to get the licenses that they need. They have an issue in being able to get the privileges that they need. And if it is too burdensome, then that could be a problem. I would hold that would be generally true for all, or at least in my humble opinion. It'd be true for all professions. So if the state is putting in regulations that are too burdensome, that don't make sense in view of the objective they're ostensibly trying to do, then the regulation is arbitrary. So if the state is putting in things that are just overly onerous, then they aren't rational, and so it would fail rational basis review. And so I think that would be generally true of any profession, not just the medical profession. Of course, the medical profession in particular has special interests in the government's regulation because of the nature of what they're trying to do, right? People's lives are quite literally on the line. So there's that, but the logic of it makes sense that the doctor would have enough of an interest, both for themselves and for the patient. So this is one of the reasons I tend to think that the standing is there. But again, third-party standing is impossibly complex, and it's not going to be a hill that I'm going to ride on.
That other women may not have brought a suit, that's irrelevant to the fact that there are some, those burdened, who could have and would have if situations had permitted them to.
That's absolutely
Well,
right,
then
Your Honor.
why shouldn't they be the ones to bring suit?
Your Honor, this is a law that restricts abortion by regulating the physicians rather than their patients. And so it's appropriate for them to be the plaintiffs here. Again, the state has pointed to
the constitutional right at issue is not a constitutional right of abortion clinics, is it? It's a right of women.
That's correct, Your Honor. But in order for women to access their right to abortion, they need to be able to access those services.
I don't particularly like that reasoning, and the reason is, like, I like to try to be intellectually consistent as much as I can about things. So in the Second Amendment arena, for example, if we talk about the right to keep and bear arms, for example, so suppose that DC, for example, or San Francisco is trying to, and in fact has, let's suppose San Francisco is trying to, and in fact has, regulates guns, not by regulating guns, but by regulating gun stores. And they say, aha, the right of the people to keep and bear arms shall not be infringed. We're not infringing the right of the people. We're just infringing on the stores by making it really, really, really hard to open these gun stores. And so I think the logic of it would still apply, right? I think in the same way the gun store, well, first of all, I think the gun owner should be allowed to sue because they can't exercise their right because the government's making it really hard. I think the business should be allowed to sue because they make it really, really hard. So there's if you think about, and if we ignore the First Amendment interests, or of newsstands in the First Amendment interest, we're not going to restrict newspapers, but we're going to really burn some rules on newsstands and news carts and all that stuff. So the same sort of logic would apply. So we're not going to go after it directly. We're going to go after it secondary, even tertiarily. And so I think that the government would be able to regulate that. And so in the same way, I think that you at least have the standing issue. I think the newsstand should be allowed to sue. And I don't know why this keeps cutting out in my ear, because I really hate playing with my ear, but this connection keeps cutting out. It's really annoying. But in the same way, the newsstand should have the right to do it, in the same way that the bookstore should, if it's being regulated, in the same way that the gun store should be able, if it's regulated. The logic of it is. So I again think there's a standing issue. I don't think there's a standing issue. I think the standing is fine.
But do you think a party can have there can be third-party standing if there is no hindrance whatsoever to the bringing of suit by the people whose rights are at stake?
This court has allowed third-party standing in cases where the law directly regulates the plaintiff without a showing of hindrance. For instance, in Craig versus Boren, there was clearly no hindrance. But I would also say that the court doesn't need to reach these issues here because the state strategically and deliberately waived third-party standing.
Well, I think that's highly debatable that they waived it. They certainly didn't raise it in the district court. But whether they affirmatively waived it is quite debatable.
Your Honor, at JA 45, the state explicitly conceded third-party standing and urged the district court to reach the undue burden claim, saying that it had a keen interest in removing any cloud upon the validity of its law, that this case was the proper vehicle for doing so.
It's a highly debatable interpretation of that passage, which I've read numerous times. What the state was saying was that if a temporary restraining order was issued, the lawsuit should continue to go forward, and they said there wouldn't be an impediment to the lawsuit going forward because the doctors would have standing. And what I think they may have been saying in that instance is that they would have standing under the law that was applicable at that time. That when we could debate what was actually said, but I think it's quite a stretch of the record for you to say there was an affirmative waiver.
Your Honor, at JA 45, there was a deliberate waiver.
I just have to pause because I really, really like this woman and how she's doing this. She's doing a really good job, and I really like it. She knows her stuff. She knows the record cold, which, isn't that surprising. But I really like the way she's dealing with this pushback. She is holding her own, but she's doing it in a very, very respectful way. And she's doing it in a way that is not, there's nothing wrong with it. It's really perfect. She said there's this waiver, and then Alito says, no, there's not. And she just simply says, yes, there is. But she's saying it in such a respectful way. Like, she's really good at this. So she is representing herself and she's holding her ground, but she's doing it in a way that's not disagreeable. It's not antagonist. It is just being and it's not being overly forward or anything. And she's not becoming more aggressive. She's not conceding ground. She's just very stoically responding to this stuff, and I really, really like it. She's doing a really, really good job as an advocate. I really like this. I really like the stoicness of her response. It's not getting more aggressive. It's not getting more defensive. It's not withdrawing. It's just being very matter of fact, plain, calm, stoic. I really admire this. This is good stuff.
And the state did it strategically because it was attempting to take advantage of favorable Fifth Circuit precedent at the time, because the Fifth Circuit had just upheld the Texas admitting privileges law. Again, the state specifically urged the district court to decide the undue burden claim, saying that this case was the proper vehicle for resolving the constitutional issues and that any delay wouldn't serve judicial efficiency.
It wasn't raised in the district court or in the Court of Appeals. It cropped up wasn't it a cross petition for cert?
That's correct, Your Honor.
And might you have, if you had a timely notice, just as insurance, joined a patient or two?
Yes, Your Honor. And in fact, it would be profoundly.
So Ginsburg is trying to give an alternate idea here that, like, if this is going to break on the fact there's no patient here as a plaintiff, that if they had notice of that they would have put them in at the original point. Now, I'm not really sure strategically why they didn't, because I would have thought you would have done it in any event. But she's basically trying to kind of moot the point, because it's like, well, we would have done it and it would have been the same, so why are we talking about it? So, not a bad idea. Pretty good idea.
Unfair to allow the state to raise the objection for the first time 5 years into this litigation after it urged the district court to decide the undue burden claim and then pursued the undue burden claim through multiple rounds of appeals. It didn't even raise the issue when this case came before the court in 2016 on this stay. The first time that it raised an objection was when it filed its cross petition for cert. And again, at JA 45, it deliberately and strategically waived this issue.
How many abortion cases has the court either expressly or silently allowed the doctors to sue on behalf of the women? I counted 8, but maybe that's overstating it. How many abortion cases in this court?
At least 8, Your Honor, and I believe at least 4 of them squarely allowed standing in precisely these circumstances.
So if we didn't in this case, it would require either directly or indirectly overruling 8 cases of this court.
That's correct. And in fact, in Danforth and Akron, the same type of law was at issue. It was a law that the state claimed was designed to protect the health and safety of women, but the court allowed the physicians to bring the claim and to show that, in fact, the law didn't further health and safety.
And how many of those cases did the court discuss the issue of conflict of interest?
The court in Danforth specifically said that the plaintiffs had standing. It wasn't discussed in terms of the words conflict, Your Honor, but again, the same types of arguments were in front of the court because the state...
Was it a footnote in Danforth?
I don't believe so, Your Honor. I believe it was a footnote in Akron, but in Danforth it was...
You made the point about Craig against Warren that the ostensible purpose of the law was to save the vulnerable young men from the evils of 3.2 beer.
That's kind of funny because a lot of people might not know this, but one of the ways that Ginsburg got her claim to fame was as a lawyer for the ACLU, and when she was counselor Ginsburg, one of her most notable cases that she argued was before the U.S. Supreme Court on the issue of whether a man should be allowed to have beer or not. So she's asking a question that is alluding like one of her most notable triumphs too. It's like back when I was lawyer Ginsburg, this is the case that basically got my attention. It got the attention, and in large part started the women's rights movement in a lot of respect too. It really helped with sex discrimination issues. So nice little aside there. I know, but that's a little bit of obscurest history for anyone who isn't super following, but good stuff.
That's correct, Your Honor. And the court allowed the saloon keeper to bring the third-party standing claim. Again, in Triplet, the court allowed an attorney to challenge a law designed to cap attorney's fees. And in Carey, the court allowed a mail-order contraceptive company to challenge a law that was designed to limit the prescription of contraceptives to pharmacists, again, claiming that that was about protecting the health and safety of people. So the court has allowed third-party standing in many cases that are squarely on point.
Counsel, do you agree that the inquiry under Hellerstedt is a factual one that has to proceed state by state?
Your Honor, I think that facts may vary, but what we know is that the district court held a trial here and found that there were no material differences between this case.
No, I know, but if the issue, the statutes are on the books in other states, and if the issues are raised there, is the same inquiry required in each case? You have to have the district court examine the availability of specific clinics and the admitting privileged doctors so that the results could be different in different states.
2 points, if I may, Your Honor. This court held in Women's Health that the Texas admitting privileges law was medically unnecessary and its burdens were undue. That holding should clearly apply to Louisiana's identical law, and certainly the court's reasoning is applicable in Louisiana. Now, the burdens of a law may vary, but a law that has no benefits and doesn't serve any valid state interest is much more likely to impose an undue burden.
If a state passed an admitting privileges law, therefore, and suppose a state had 10 clinics and 2 doctors for each clinic, but all 20 doctors could easily get the admitting privileges so that there'd be no effect on the clinics, no effect on the doctors who perform abortions, and therefore no effect on the women who obtain abortions. Would a law be constitutional in that state?
That law may still be unconstitutional if it's restricting access because of the 30-mile limit, Your Honor, but that's very different from the situation here where the district court concluded—
If it didn't, I'm sorry to interrupt, if it didn't, though, put aside the 30-mile, assume all the doctors who currently perform abortions can obtain admitting privileges, could you say that the law still imposes an undue burden even if there were no effect?
That law would have no benefit, Your Honor, and it may pose a much harder question than this case. But in this case, the district court, after a trial, explicitly found that the burdens of this law would be severe, and it would leave only one physician to serve 10,000 people per year in the entire state.
Well, the Fifth Circuit went through what the district court had said about the various doctors, and it was proper for the Fifth Circuit to review the district court's findings for clear error, was it not?
Yes, Your Honor. Clear error is the standard, and we believe that the district court's findings are more than plausible under the standard here.
Well, let's take one example. Let's take Doe number 2. Doe number 2 is a plaintiff in this case, right?
Yes, Your Honor.
So it would be counter to his own interests for him to make a super effort to get admitting privileges, wouldn't it? Because he'd be defeating his own claim.
No, Your Honor. Doe 2 brought this lawsuit to protect the rights of his patients, and the district court found that he was competent and qualified and that he made good faith efforts
all
to
right, so all right, we can argue about whether he has a conflict of interest or not. He previously had admitting privileges at a hospital in the Shreveport area, did he not?
Yes, Your Honor.
Predecessor of Christus Schumpert?
Yes, Your Honor.
He testified that he didn't apply for admitting privileges there because it's a Catholic hospital. Isn't that right?
That was part of the testimony, but in addition, the bylaws of that hospital showed that there would be admissions requirements that Doe 2 couldn't.
All right. Well, he testified directly, I did not apply there because it's a Catholic hospital. Is that not correct?
That's correct, Your Honor.
All right. Doe number 3 performs abortions, does he not?
Yes.
Doe number 3 has admitting privileges there.
He has admitting privileges that require 50 admissions per year, which he's able to satisfy because he has an obstetrics practice, and that's why he was the only physician with privileges. The state's own credentialing expert in this case conceded that outpatient physicians like these, who never intend to treat patients in the hospital, will not be able to get privileges, and the hospital bylaws included many criteria that these physicians could never satisfy, including
Doe
residency.
number 2 explained why he didn't apply to this hospital, he said in part because it's not a place where I would feel comfortable. Didn't he say that?
He did, Your Honor. Doe, too, focused his efforts on hospitals where he thought he had the best chance of obtaining privileges. He had privileges at LSU and wasn't even able to get privileges there.
Did the district court mention any of these facts?
Yes, Your Honor. The district court's opinion was very careful, and its decision and finding that these physicians would not be able to get privileges was based on at least 4 points. One, the fact that they applied and attempted to get privileges at 15 hospitals over 1.5 years. Two, that the state's key credentialing expert conceded that physicians who never intend to treat patients in the hospital will not get privileges.
Footnote, that's doctor number 6.
All of these physicians are outpatient physicians, Your Honor.
No, but number 6 is only a medical doctor.
That's correct.
He hasn't done any surgical procedures since 2004 and 2005.
That's correct. And the state's expert also conceded that a physician who provides only medication and counseling would never be able to get privileges. In addition, the district court's burdens findings were supported by what happened when this law actually took effect for a brief time in 2016, and abortion access in Louisiana was devastated. And of course, the finding of every district court that has held a trial on a similar law has been that these laws will restrict access to abortion. And here the district court found that this law would leave Louisiana with just one clinic in one state to serve about 10,000 people per year. And that would mean that hundreds of thousands of women would now live more than 150 miles from the closest provider. And the burdens were actually more severe than this court found in Holman's Health.
Can I go to Doe 3? The doctor who had the active OBGYN practice, he's only a part-time doctor in Hope.
That's correct.
There's been much talk about his statement or findings by the district court that he was a superseding cause to the act because he, on his own, will not practice in Hope if this law goes into effect because he would be the only doctor. But putting that aside, he also testified, the Hope manager testified that he only does a limited number of abortions, and without the other doctor, that clinic would have to close.
That's absolutely right, Your Honor. The district court found that without Doe 1, the primary provider at Hope would not be a viable going concern. So regardless of Doe 3's testimony, Hope would have to close because Doe 3 was providing fewer than 30% of the abortion services of that clinic. The primary provider was unable to get privileges, and Hope would close, meaning that women living in northern Louisiana would now have to travel hundreds of additional miles for a law that has no benefit in order to access abortion services.
I also like the way she's advocating in terms of putting in the consequences of the ruling in her argument. I like the way she's pacing it out. I like the way that she referred 2 or 3 times to the district court's factual findings and what they said in terms of the impact and how this is going to really impact people. And I like what she was just doing there in terms of saying that, that there's no benefit here, right? So one of the things that you are always looking to is cost-benefit analysis, right? So we'd be looking like, what is this trying to do versus what harm is it trying to do? And so it's like, well, what is that in terms of the balance here? And there's nothing here. So I like the way she's bringing it up. I like the way she's interlacing it. I like the way she's responding on her tone. I like the way that she's very matter of fact, very calm. She's a really, really good advocate. I really like her arguments. And just like a lot of this is going to be like fact specific too, right? Like how much will it really matter in the real world? This is one of the things we were discussing in the introduction to the stream. one of the things I said is you could try to separate this on the facts. You could try to separate what the reality of Texas was versus the reality of Louisiana was, and how much it is or is not impacting, and the degree to which undue burden is or is not. So that's one of the questions here. And going back to the trial court and saying that this is factual is actually very helpful, because then, of course, to the degree it is, that takes it out of legal, and therefore, presumably, takes it even out of the Supreme Court's concern. Now, they did note that the Court of Appeals was trying to reverse some of this on a clear error standard, and then she said, well, they shouldn't have, so then it becomes a legal question as to whether or not there was clear error or not. But I really like the way she's advocating. I like the way she's interlacing this. I like her tone. I like her responsiveness. I like her pacing. I like everything about this. It's just really sharp. It's really easy to listen to, easy to respond to. There's nothing aggressive about it. There's nothing beating at the... She's raising the parade of horribles in a very sort of calm, intellectual way. I really like the way that this is being done. So she's really solid, so whoever found this woman, they found one hell of an advocate.
There's no dispute here about Doe 1.
That's correct.
The other side, that finding, it says it's right. Now Doe 3, whether or not he would quit or not, the clinic would have to close because it wouldn't have a Doe 1.
Correct.
So at least with respect to that. With respect to Doe 6, that's a medical doctor only who hasn't been in a hospital for over 10 years. So it seems implausible, given that every single hospital mentioned by the district court in that area has requirements of inpatient, of receiving patients by the doctor, and he can't fulfill that under any circumstance.
That's correct.
Can I follow up on the Chief Justice's earlier question and mine as well? Are you saying that admitting privileges laws are always unconstitutional, such that we don't have to look at the facts in state by state? Or are you saying that actually you do look at the facts state by state, and in some states admitting privileges laws could be constitutional if they impose no burdens?
Your Honor, the burdens may vary, but a law that has no benefit and serves no valid state interest, which is what this court held in Women's Health, is much more likely to be an undue burden.
Could an admitting privileges law of this kind ever have a valid purpose in your view?
No, Your Honor. The medical consensus against these laws is clear.
So your view is that they're unconstitutional in any state, regardless of the facts?
They certainly serve no valid state interest, and in fact, the district court here found that this law was a solution for a problem that didn't exist and would actually jeopardize the health and safety of people in Louisiana.
Would this be different if they did something as limited as, for example, you have to be admitted somewhere? Because being admitted somewhere does further credentialing benefits. But this was, you have to be admitted within 30 miles. Some of these doctors were admitted further away, but they still were credentialed by someone, correct?
That's correct, Your Honor. If credentialing were the true goal of this law, the 30-mile limit would make no sense. And one of the practical real-world impacts, if this law were to take effect, is that women in the Baton Rouge area would now have to travel 320 miles back and forth to New Orleans to see the same exact physician that they previously could have seen in Baton Rouge.
How many miles from the Hope area?
It's 320 miles, Your Honor, from Shreveport to New Orleans. And from Baton Rouge back and forth, because of the True Trip law, it's 320 miles. And again, they would be making that trip to see the same exact physician who had been previously providing services in Baton Rouge, and that has no benefit to women's health. It will only hurt their health, which is exactly what the district court found here.
You haven't mentioned, it's odd, the 30-mile from the clinic, when most of these abortions don't have any complications and the patient never gets near a hospital. But if she needs a hospital, it's certainly not going to be the one near the clinic. She will be home.
That's exactly right, Your Honor. That's what this court recognized in Women's Health, and one of the reasons why it concluded the law is medically unnecessary, because the complication rate is extremely small to begin with, but when complications do occur, it's almost always after the woman has left the clinic, and the standard of care at that point is for her to go to the hospital closest to her home. And of course, about 40% of abortions in Louisiana are medication abortions, and any complication from those abortions will always happen when the patient is at home, which again is what this court recognized in Women's Health. And that is one of the reasons why the AMA and ACOG are clear that these laws have no medical benefits whatsoever and only impose barriers to abortion. And that is true in every state, regardless of the state circumstances. These laws will always put barriers to abortion while serving no health and safety benefits. And in fact, the district court here found that abortion in Louisiana in the years before the law was extremely safe with a very low rate of complications, that HOPE had an excellent safety record, and that its physicians were competent and qualified to provide abortion services. And again, it concluded that there is no basis to distinguish this case from Women's Health, and instead the burdens of this law would be even more severe than the Texas law that this court struck down in Women's Health.
HOPE is the name under which June Medical does business, is that correct?
Yes, Your Honor.
Was June Medical's license suspended for regulatory violations?
It was briefly, Your Honor, in 2010, and the court heard testimony about that and rejected the state's allegations after listening to the clinic's administrator and looking at the evidence in the record. It concluded that HOPE has an excellent safety record and that its physicians are qualified and competent.
Thank you, counsel.
So, not a whole lot to say other than what I've been saying so far. She's well informed. She knows the facts. She knows the law. She knows what happened, and she's a very, very good advocate. She's laying it out very well. She's laying out the consequences very well. She's not doing it in a way that hits you over the head. She's not doing it in a way that's even judgmental. She's just doing it very sort of matter-of-factly and very sort of responsibly, and she's not getting overexcited from good questions, from people who are trying to support her. She's not getting overly. She's just remaining very calm and cool. Whatever this woman does for meditation or breathing exercises or yoga or whatever it is, I want to know more, because she's way calmer than I could ever be. So I don't know if it's an issue of practice or whatever, but it was really, really good. And then okay, so yeah, it makes sense. So it'll be interesting to see what we have next in terms of the solicitor. So let's see what the solicitor has to say for us in terms of this.
General Murrow.
Thank you, Mr. Chief Justice, and may it please the Court. The Fifth Circuit correctly held that the plaintiffs in this case failed to carry their heavy burden of proof that is required to facially invalidate a state law. Louisiana's decision to require abortion providers to have admitting privileges was justified by abundant evidence of life-threatening health and safety violations, malpractice, noncompliance with professional licensing rules, legislative testimony from post-abortive women, testimony from doctors who took care of abortion providers' abandoned patients. The substantive due process claim that plaintiffs assert on their patients' behalf hinged upon their assertion that they would not be able to get privileges, but they can, and they did. Their claims also fail for an independent reason. So they do not meet the modern rigorous rule for third-party standing. So instead, they invite this court to exempt them from the rule. This court should decline to make abortion providers unique among federal plaintiffs and reaffirm that even abortion providers must comply with the same rules as all the other litigants. Doctors and healthcare providers and healthcare facilities are heavily regulated for ethics reasons and for consumer protection.
Yeah, so I think that this is a fair counter to Stephen Breyer's question from earlier, because the third-party standing issue, as I've said before, is complicated, not my area of expertise, and I don't know the case law well enough to really offer an opinion on that particular point. And so when he was saying that there have been 8 cases before where we have allowed third-party standing under whatever similar circumstances there are, I think that is the wrong metric in a lot of ways. That is not the right issue, because it's not like I think she has the better end. It's not like the third-party standing rule should be different there as opposed to anywhere else. So it's not really proper to say, well, the court did it in these 8 other times, without considering how they're doing it in general, and it's sort of the way that the third-party standing issues have moved. So I think it's a good thing. So she's basically saying Justice Breyer was asking the wrong sample set. He's looking at the sample set of abortion cases, which is the wrong sample set. He should be looking at the sample of all cases, which I think is the better sample set, because the issue of standing does nothing to do with abortion. It has to do with standing. And so she has a better end of it. So, okay. So I don't know the degree to which you would necessarily have to overrule any of those cases, because the cases have been moving along anyway. So, okay, fair enough. Let's carry on.
And in this context, the conflict between the plaintiffs and the individuals that the law seeks to protect should defeat the close relationship prong of third-party standing. Apart from that conflict, the record shows that they do not have a close relationship with their patients, and individual women have litigated abortion cases on their own for decades. I'd like to first address why this case is different from Hellerstedt, and then address standing and waiver. The state presented abundant evidence of how this case is different. The law is different, the facts are different, the regulatory structure is different, and the record is different. And all of those things dictated a different result. So the Fifth Circuit focused on one of the things that the Fifth Circuit focused on was credentialing. The record in this case demonstrates that there is no credentialing that is performed by these facilities. They alleged that they had robust policies, but they don't read them and they don't follow them.
What sense does the 30-mile limit make, considering that certainly for medication abortions and for the overwhelming number of other abortions, if the woman has a problem, it will be her local hospital that she will need to go to for the care, not something 30 miles from the clinic, which does have no necessary relationship to where she lives.
Justice Ginsburg, that regulation is consistent with the regulation that we have in our office surgery regulations and our ambulatory surgery regulations, so it is consistent with our regulatory structure. We also had evidence in the record of women who did require transfers. I think there is at least 03 testified unambiguously that he had to transfer 4 patients who had punctured uteruses and were hemorrhaging, and he took care of them.
What about a D&C after a miscarriage? As I understand it, these two procedures are very much alike. Are similar regulations about 30 miles and admitting privileges applicable to a D&C following a miscarriage?
Under the ambulatory surgery center regs, yes. Under the office practice regs, which do not regulate abortion clinics, a doctor who doesn't have a residency in the proper scope of care would have to have admitting privileges and would have to have them within 30-mile radius of the clinic. So it's the same requirement.
It is the same.
Yes.
I thought there was something in the record suggesting there was no such requirement for D&C following a miscarriage.
The office practice regulations are not as tightly regulated as ambulatory surgery centers, which are facility licensing. These are separate licensing constructs. Facilities are licensed by the Louisiana Department of Health, as are ambulatory surgery centers, and both require all the medical staff to have admitting privileges. The requirement under ASC says geographically close, and it is interpreted under the regs as the same way. So we don't interpret it differently. We're applying them consistently, and we're reading those regulations the same.
Do you agree that the benefits inquiry under the law is going to be the same in every case, regardless of which state we're talking about? I mean, I understand the idea that the impact might be different in different places, but as far as the benefits of the law, that's going to be the same in each state, isn't it?
No, I don't think benefit. I mean, I think that a state could certainly show greater benefits depending on what their regulatory structure is and what the facts are on the ground in that state. I think we absolutely could show that it serves a greater benefit. In our situation, for example, we've demonstrated that the doctors don't do credentialing, that the LSBME testimony from the executive director, from Dr. Mouton, in the record, at JA 1373, she testified specifically that the LSBME doesn't do credentialing for procedures. That's what the hospital would do, and that's what, if the clinic had robust policies, it would do.
I'm sorry. There are laws that require credentialing to be done by the state with respect to these doctors, correct? They have to get a license, and they have to have certain competencies to get the license. And the license is suspended if they're convicted of a criminal act. You're making it sound like there is no state licensing of these doctors. They're licensed. They are regulated.
Sotomayor, they are licensed by the state and Dr. Cecile Mouton testified specifically at JA 1373 that the board does not do credentialing. That is not our role. Our role is to license you generally.
Didn't they also testify that they did ensure that each of these doctors was skilled in the procedures that they were performing?
No. In fact, Doe 3 hired a radiologist and an ophthalmologist to perform abortions at one point in time. So they clearly were not
But
complying.
He was supervising what they were doing. That's what he testified to.
That is not within the scope of care, and our record clearly demonstrates that you should have a residency and you should have training in the area in which you are performing surgical procedures. So it would not comply even with our office practice regs for a radiologist to perform abortions. That would not comply with our
Was he doing a
standard.
surgical procedure, or was he doing a medical abortion?
He was performing surgical abortions. To the best of my knowledge, there's no indication that he wasn't. I believe that the testimony is that he was performing he wasn't restricting his practice. There's not a lot of testimony in the record about what those doctors were doing, other than he hired them. But to your question,
we're not even talking about them. We're talking about these doctors and their credentials. I'm sort of still at a mystery to me. Why, if what's important to you is the credentialing, why the 30-mile limit has significance?
Because it's not just credentialing. It is all of the other factors that also play into it. It does provide continuity of care. It does address the noncompliance with health and safety
regulations. There is no continuity of care. This law itself permits a doctor to either have admitting privileges or to be in contract with someone who does. So it's not necessary that there be continuity of care in a hospital. The only thing is the credential, you said, is to make sure that they have the skill level. But if they're credentialed somewhere else, they have the skill level.
Justice Sotomayor, they did not even comply with the transfer requirement. They did not comply with multiple health and safety requirements in the state. So part of what the credentialing...
Was this all before the district court?
Yes.
All right, and the district court looked at it and found explanations that were adequate for each and didn't come to the conclusions you did or the legislature did. I thought the standard of review for the Fifth Circuit here was whether there was a plausible basis in the record for the conclusions the district court reached.
The district court judge ignored all of the health and safety violations. He ignored an entire category of courtesy privileges if we're talking about compliance. I mean, I would like to take us back to the point that they could and did get privileges, and their primary assumption from the beginning was
Before you do that, please, on this credentialing point, which you've mentioned several times, and of course, Whole Women's Health discussed that and said a state can't say it's doing this for credentialing purposes if the hospital's reasons for denying admitting privileges have nothing to do with the doctor's quality. And that was true in Whole Women's Health, and it's true here too, that there's a great deal of evidence in the record that indicates that admissions privileges rest on many things. It could rest on qualifications, but it could rest on the number of patients a doctor has. It could rest on whether a particular hospital needs more providers. It could rest on a general view that they don't want abortion providers in that hospital. So given that that's all true, it was true in Texas and it's true here, it seems that Whole Women's Health precludes you from making this credentialing argument, doesn't it?
No, I don't think that it does at all. I mean, in our case, it was demonstrably different. They could and did get privileges. So all of the conjecture and the speculation about the reasons why they might be denied privileges were proved to be untrue. They were able to get privileges.
Is it not the fact that most hospitals in Louisiana, in order to get admitting privileges, you have to admit a certain number of patients? Abortion providers will never, if they're not also doing obstetrics and gynecology, they will never qualify because their patients don't go to the hospital. There's one finding in that respect that you can tell me if there's any dispute about it, but Fifth Circuit didn't seem to contest this finding of the district court, that a hospital transfer was required far less than once a year or less than one for several thousand patients. Most of the people who get abortions never have any need to go to a hospital. Isn't that so?
Justice Ginsburg, to your first point about the privileging and the minimum requirements, every set of bylaws in our record shows that there is a category of courtesy privileges that permits low admit from anywhere from 0 to a dozen.
My question is there anything inaccurate about this determination that the access to a hospital was required far less than once a year, less than one for several thousand patients?
Yes, it is inaccurate because what the record demonstrated is that they don't know what their complication rates are. They all testified that they don't know because women don't follow up with them or they don't follow up with women. So they really don't know what their complication rates are, and they did testify that they had direct transfers that resulted in women having hysterectomies and hemorrhaging.
Is it right that there is evidence in the record that Hope Clinic has served over 3,000 women annually for 23 years, so that's around 70,000 women, and has transferred only 4 patients ever to a hospital?
And there is evidence in the record that they really don't know that that's an accurate rate because they don't track their complications. They really don't know what their numbers are. So they testified to that.
They know whether they've transferred women to a hospital, and it's 4. I mean, I don't know of a medical procedure where it's lower than that of any kind.
Justice Kagan, it's 4 that they know of, and that they don't track the numbers.
You don't dispute that among medical procedures, first trimester abortion is among the safest, far safer than childbirth.
Justice Ginsburg, a first trimester abortion can be either medical or surgical, and even if it's medical, the doctor should have the qualifications to be able to handle the most likely complication of that procedure, which is a surgical abortion. So under the standard of care in Louisiana, even if it's a medication abortion, the doctor should be able to handle a surgical abortion and be qualified to do that. I think the record is questionable about whether Doe 1 can even do that because
Doe 1, everybody agreed, including the Fifth Circuit, that Doe 1 is barred by this new law. The old law said that you have to have admitting privileges or a written transfer agreement. So it's a little hard to see how this improves anything, since you had to have a written transfer agreement anyway. Isn't that true or not?
Which Doe 1 did not comply with.
Well, all right. But then I don't know why the Fifth Circuit Court of Appeals, which seemed to have problems with the district court, agreed with the district court as to Doe 1. But that isn't my question. My question is, we're not going to solve this in oral argument. I mean, what I've done, and I'm sure the others have, is I've gone through the district court findings, and I have gone through the Court of Appeals findings, and I have looked at the relevant bits of the record through my office, and will do more of that. So I think Doe 2 is your weakest case. I think there are others that are stronger. But I'd like your opinion about which of these does is your strongest. And I'll be sure to look very carefully at that.
Justice Breyer, I just want to understand your question.
I'm saying which is strong. By the strongest, I mean you're trying to make an argument. And you have 4 does that you have to deal with. Okay? So I want to know, of your opinion, in respect to which doe is your argument the strongest. Your argument is that the Fifth Circuit was right to overturn a fact finding, and with Doe 3, a credibility finding of the district court. That's your argument. Now, you have to support that, and I want to know in respect to which Doe do you feel it's the strongest support for you.
Can I go in order? Can I give you more than one?
You can give me all of them if you want, but you don't have that much time. And if you have a feeling off, you want to say they're all equally strong, fine. That's okay. You can say that because I have an opinion about Doe 2 at least. And you can say what you want.
Well, I mean, I think that there's evidence in virtually all of them that they sabotaged their own applications, and that Doe 5 Doe 5 obtained privileges in Baton Rouge and New Orleans, asked only one doctor to back him up in Baton Rouge, and all of the doctors agreed that is not difficult to satisfy. Doe 2 simply...
They don't all agree. I mean, I don't think. But we're not going to get... all I want to know is a number. And the reason is we have limited time, and I could spend 2 hours discussing with you Doe 2, 3, 4. All I want to know is which should I look at especially hard?
I would look at Doe 6, who applied to 1 out of 9 hospitals in New Orleans. That's a good example.
That's a great example. Because he's the doctor who does only medical abortions, not surgical. He hadn't done a surgical procedure for over 12 years. And your state's own expert testified that it was not likely that he was going to get privileges anywhere because he only did medical procedures, never saw a patient. In virtually all of the hospitals, if not all of them, even if there wasn't, like in Tulane, even if there wasn't a minimum number of patients that had to be admitted before you got privileges, you had to see a certain number of patients in the hospital per year to maintain your privileges. And he couldn't meet that requirement. So you talk about him applying to only one hospital in a situation where it was guaranteed that he couldn't meet the requirements of any hospital. My understanding of hospital practice today is you got to stay alive only if somebody sees patients. Because if they don't see patients, they're of no value to the hospital. If the patients aren't admitted and there's no circumstance in which this doctor is going to admit a patient because he does no surgical procedures.
Justice Sotomayor, I think the record shows that they can get privileges. They did get privileges, and there's nothing in the bylaws that prohibits them from being.
But your own expert, Dr. Marier, testified. It is unlikely that a doctor who, like Doe 6, does what Justice Sotomayor said, would, quote, probably not, end quote, be able to obtain, quote, active admitting and surgical privileges, end quote. Now, that was your expert. And the basis of that and various other things, the district court finds that he didn't have to apply to all the hospitals because there was no point because your expert said he probably could not get them. And it's on the basis of that kind of thing that the district court held that he was likely not to be able to practice. Where does the Fifth Circuit able to say that that was clearly wrong?
Justice Breyer, the Fifth Circuit did a searching review of the record just as it is instructed to do by Whole Women's Health. And in the brief amount of time that I have left, I would like to say just one thing about standing. I think that the record is the reason why it demonstrates that these doctors should not be able to challenge a regulation that protects people, that is intended to protect a class of people from a certain type of activity. It's health and safety regulation. regulations. As a practical matter, and even yesterday this court was talking about the fact that consumers are protected by certain body of laws. That's what we are doing with health and safety regulations.
How does that differ from Craig against Boren?
Craig against Boren, first of all, had a beer buyer who was a first-party plaintiff in the beginning of the case all the way through until it was on appeal. In addition to that, the state
he didn't count. The case rode on the owner of the Honk and Hollers standing. Craig turned 21. He was no longer subject to the law.
Which is why I believe it's better characterized as a mootness case, but I would also point out that the law at issue...
The court went on to the merits solely on the basis of the beer seller's standing, and you had a state regulation that ostensibly was designed to protect these vulnerable boys from drinking beer and getting into accidents.
It's a dangerous...
Very, very briefly, counsel.
Justice Ginsburg, my answer to that is that the buyer in that case was much more just a financial transaction. Their interests were better aligned because he was not prohibited from consuming or possessing the alcohol. So it really wasn't a health.
Thank you, counsel.
And just by the way, that was the Solicitor General of Louisiana. So now we're moving on to the U.S. government as amicus curiae. So let's listen to what the U.S. government has to say.
General Wall.
Mr. Chief Justice, and may it please the court. Petitioners' counsel began this morning by saying that this case is about respect for the court's precedents. But she went on to acknowledge two rather remarkable propositions that flow from the logic of petitioner's position and that are nowhere to be found in the court's cases. To you, Justice Alito, that the plaintiffs may bring this suit even if there is a potential or actual conflict of interest with Louisiana women. And to you, Justice Kavanaugh, that this law would be unconstitutional even if all providers in Louisiana already had admitting privileges or could easily get them. I do think, though, petitioners did acknowledge what is in the court's cases, which is, to your question, Mr. Chief Justice, that the burdens may vary by state. At that point, under the substantial obstacle test, we ought to be talking about Does 2, 5, and 6 and how much of a burden there actually was on them instead of pivoting to the benefits. And to you, Justice Alito, that's not a clear error question. Nobody disputes what the doctors did. We're all agreed on the facts. There's no factual dispute about what the doctors did and didn't do. It's about how rigorously we're going to review their fairly modest efforts.
In what sense does this 30-mile, that's what I don't understand. I think everybody also agrees that the most likely place the woman will be if she needs to be in a hospital, she'll be at home. She won't, and her home has no necessary relationship to 30 miles from a clinic.
So 2 points, Justice Ginsburg. Again, that's going straight to the benefits and bypassing the burdens, not looking first at whether there's a substantial obstacle, but to go straight to your question. All admitting privileges requirements of which I'm aware, and they're fairly uncontroversial in the medical field, have some distance limitation. And I think the benefits that they go to, the most obvious is the continuity of care, right? Because you want the doctor to be able to admit them at some nearby hospital, and at least in some rural areas, there isn't always a hospital right around the road. So whether you draw it at 15 or 20 or 30 miles. And with respect to credentialing, it makes sense to think that the doctors...
It's the post, starting out from the clinic where she won't be. She's not going to be at the clinic.
Well, that's often true, Justice Ginsburg, but the record here, unlike in Hellerstedt, reveals that sometimes it's not true, that sometimes women develop complications in the clinic, and in fact, Doe 3, who I think on this record is probably the most competent of the Does and is the medical director at Hope, said that he has, on occasion, had a patient who develops a problem like a perforated uterus and admitted in the hospital and treated it. So even Doe 3 thinks of that as a best medical practice. Now, granted, we don't know how often it happens, and Justice Kagan, I'm prepared to concede that it may not happen all that often. I don't think anybody knows the real rate. But the point is that it does happen, and when it does, it's very serious. In Louisiana...
It would never happen for when you go to the clinic just to take 2 pills and go home.
Well, if you develop a complication at home, it's not it's not clear that you won't call the clinic and say to your doctor, I'm having a problem, and your doctor will say, then go to the following hospital where I have privileges, I'll meet you there. Now, that's not to say as a patient that's necessarily what you'd want, but it's hard for me to believe that women in Louisiana wouldn't at least want the option to be treated by the doctor they saw at the clinic.
Are you taking the position that there is no woman in Louisiana who doesn't feel burdened by this law?
I'm taking the position that...
No, answer that question.
Well,
is there at least one potential woman, do you believe, that could bring this lawsuit?
I assume that there are, but they have not sued.
Now stop a moment. We assume, because it's logical, okay? The woman who lives there's going to be some woman who lives 330 miles away who's going to say, that's an unusually long period of time for me to have to drive and then drive back the same day, all right? But or the next day, putting that aside, where is there a conflict between that woman and the doctor? If that woman is going to take the position that this law unduly burdens me, what's the potential conflict? She's going to come in and say, you doctors could get credentialing, so I really shouldn't sue? You doctors haven't really made an effort, so I really shouldn't sue? What sane woman who's a plaintiff is going to have a conflict with a doctor who wants to protect her rights by doing what they can to comply with the law or not, but their interests are not misaligned. They want to achieve the same holding, that this law unduly burdens her right to abortion. I don't see a conflict with that.
I would say two things, Justice Sotomayor. Their interests are not necessarily aligned. One is the interest of for-profit providers in not being regulated in particular ways. The other is the interest of women in their own health and safety. Now, I don't know how those would have played out if the women had filed suit. I don't know how they would have. But to give you a couple of examples, just to give you, it's not clear to me that women would have brought a facial challenge. Maybe all of the current providers in Louisiana.
How do you deal with this? I mean, I have read the briefs. I understand there are good arguments on both sides. Indeed, in the country, people have very strong feelings, and a lot of people morally think it's wrong, and a lot of people morally think the opposite is wrong. And in Casey and the later cases, I think personally the court is struggling with the problem of what kind of rule of law do you have in a country that contains both sorts of people. Not all right. So therefore I take Casey as given. And I think 8 cases where you've given standing. I mean, we could go back and re-examine Marbury versus Madison. But really, we have 8 cases in the abortion area, we have several cases in other areas, and Whole Women's Health picks that up, Casey picks that up, and you really want us to go back and re-examine this, let's go back and re-examine Marbury versus Madison. And you have good arguments. But why depart from what was pretty clear precedent?
I don't want to go back to 1789, Justice Breyer, but I do.
You want to go back for 40 years?
Well, I think what we want to say is that in none of those cases has the court ever considered and signed off in the face of a potential or actual conflict of interest. So yes, this is an argument that's never been in front of the court, and we don't think the court now faced with it should accept it.
General, I know you have limited time. I understand the point that the impact of the laws varies from state to state, but why do you look at each state differently if the benefits of the law, they're not going to change from state to state?
So I disagree, Mr. Chief Justice. I think that the variance isn't going to be as wide as on the burden side. But take credentialing, for instance. I think the petitioners would have to say that if you had a state that really did focus on competence and the hospitals really were vetting for competence, now they can dispute whether that happens here.
I mean, that wasn't this case, right?
Well, I would say that competence is, I think, a pretty key factor in what the hospitals do. And if you look at the
on this record?
I think if you look at the Joint Commission standards that are in the record, but my only point to the Chief Justice was that however we think about that, they can vary depending on how the credentialing system works in a particular state. If I could just make one last point on the merits, I don't really think it's a clear error standard, Justice Alito. It's how rigorously are we going to review pretty modest efforts. Doe 2 did not apply to a hospital where he used to have privileges, and Doe 3 currently has privileges. Doe 5 got privileges at Toro Hospital in New Orleans and just needed to get a covering doctor in Baton Rouge, and Doe 6 didn't apply to Toro in New Orleans where Doe 5 has privileges. So Doe 5 did the thing that petitioners are here saying can't be done, and it's hard to figure out what the basis for distinction is, because the sites they give in their brief, and it's pretty general and pretty thin, to be honest, but when you really trace it back, it seems to be the hospital bylaws. And Toro, as best we can tell, seems to have bylaws that look like the ones that they say would keep people from getting privileges.
Answers, each of those has an answer. I mean, they say, look, the ones who did get the privileges practice an OBGYN practice, and so they had women who, in fact, were admitted to hospitals. And the ones who don't are the ones who do medical abortion. You've heard that. Okay? And on the other one, as far as, Doe 2 says, I tried to get a covering doctor. He said no. The other covering doctors, there's no point because I'm in Baton Rouge. Is that where he was? I think, Doe 2. And he said, look, it's a tougher climate here. Really tough for people who perform abortions. Quite different from New Orleans. And I was told by one that don't do it because you try to get the covering doctor and that doctor will be subject to picketing, da-da-da. Okay, we've all seen that. So we've gone through it. We'll go through it more. What do you want to say?
So I think Doe 2's in Shreveport, but far more importantly, what I'd say is this. In a pre-enforcement setting, that sort of debate back and forth isn't enough to carry the burden. What ought to have to happen is these physicians ought to have to put their applications where their mouths are, and then we'll find out once they've applied to the full range of hospitals whether they really can't, whether Doe 2 really can't at Christus, whether Doe 5 really can't find a covering doctor in Baton Rouge, whether Doe 6 really can't at Toro. But on this record, I'm very skeptical that they can't.
Is it not a reality, is it not really the fact that almost all hospitals in the state of Louisiana do have an admission, you have to have an admission record in order to admit patients. There's something in the record to that effect that you don't get. If you don't send patients to the hospital, you don't get admission privileges.
You may answer.
Justice Ginsburg, I think that's difficult to square with the fact that Doe 5, who does not have an OBGYN practice, got privileges at Toro. I think petitioners acknowledge that they're not explicit patient minimums. They call them implicit, but the kinds of requirements that they are pointing to are the sorts of things that look like they would have precluded Doe 5 and didn't. These ought to play themselves out in a post-enforcement context, not as here.
Thank you, General. 5 minutes, Ms. Rickles.
So when he's talking about post-enforcement versus pre-enforcement, as you might imagine, this was brought up like as soon as the law went into effect, right? So it's brought up as a facial challenge, effectively. And so he's saying, well, we don't really know what will really happen in the real world because it might be fact-specific. So, that's a fair point too. But then again, the district court did a lot of factual analysis, and we're still back into the issue of did the Court of Appeals properly review that analysis because it's clear error and what is the standard. So, this is a pretty complicated legal question. This is one of the more complicated legal questions I think we've covered on Supreme Court React. But let's finish this out. And El Rio Grande, yes, I have noticed the uptake in my viewership and subscribership. I have gained 900 subscribers in the last 28 days, which I'm very happy about. So, yeah, and we've got 57 people watching this and only 19 likes. But, hey, we're making lots of progress growing. I'm very excited about that. So we're just going to keep doing what we keep doing. And, it's all good. So let's finish this off. Oh, and by the way, I don't know if I mentioned this earlier or not, but anyone who happens to be watching, I know someone asked me in a comment. I did send an email to Nick Rikita about the Vic Mignogna thing, and he in his live stream said that he saw my email and would get back to me. He hasn't gotten back to me yet. He has his own schedule, and I'm not, if he can't fit me in, he can't fit me in. If we have a discussion, that's fine. But just to let people know, I did reach out to Nick Rikita, and so if we have a discussion on that, that'd be cool. So, anyways, let's finish this up.
Your Honor, the lack of benefits of these laws is not state dependent. The medical consensus is clear that in no state do they serve health and safety benefits. And in fact, even the federal government a few months ago removed an admitting privileges requirement from its regulations of surgery centers nationwide, finding that the requirement is medically unnecessary and imposes burdens. And as Justice Kagan asked, this court rejected an alleged credentialing benefit in Whole Women's Health. And after holding a trial, the district court rejected that this law would serve a credentialing benefit in Louisiana. With respect to burdens, the district court found that this law would be extremely burdensome, more so than the Texas law in Whole Women's Health. And its finding that these physicians would not be able to get privileges is supported by at least 4 aspects of the record. The fact that they tried to get privileges at 15 hospitals over 1.5 years under the court's supervision. The fact that the state's expert conceded that outpatient physicians who don't have a hospital-based practice are unlikely to get privileges. The fact that abortion access was thrown into chaos when this law actually took effect, and the hospital bylaws themselves, which included a variety of criteria that these physicians could never meet, including residency requirements. And finally, I'd like to point out that this is not, in fact, a pre-enforcement challenge. The state has recognized that, including in its state papers before this court. The district court allowed the law to take effect, but enjoined its penalties and supervised the physician's efforts to get privileges over 1.5 years. Again, the state has previously acknowledged that this is not a pre-enforcement challenge. If there are no further questions.
Thank you, counsel. The case is submitted. We'll
Cool.
hear argument this morning.
Well, we're not definitely listening to that twice. So that was really good. Really, really hard argument to forecast. It's really hard to forecast because it's going to get down into the weeds of the minutiae. I think it's going to get down into some pretty specific stuff. Man, it's so hard to predict because you're also faced with the posture of the Court of Appeals basically overturning the district court on the facts, which, you have to, is a skeptical thing. So it's like, to what degree do you want to go do this? I think this could go a lot of different ways. It's hard to predict. I could see a lot of outcomes. I think the most likely outcome is, no matter what the decision is, though, it's going to be pretty fact specific. I think it's going to be pretty rooted in the exact factual posture and the exact factual reality of it. So I think the best is it's so the district court enjoined, the Court of Appeals overturned, and so I think the best outcome therefore is 5-4 overturn. Yeah, I think Roberts is on the other side of this, and I think it's going to be rooted in a pretty fact specific thing. So I think 5-4 to reverse is probably good, and it's going to be rooted a lot in the district court. It may be rooted in just the idea that the Court of Appeals didn't give the amount of. It may be just rooted in something as simple as the Court of Appeals did not give the right level of discretion to the trial court, and end of case, without talking about anything of the substance of it. So it might just be 5-4. Court of Appeals, you were too strict in your review of the factual findings of the trial court. You shouldn't have done that. End of case. Now, of course, when I say that, I know, and it's going to be 30 pages, 50 pages long. So that is the too long didn't read version of whatever the court is going to say. But I think that's the best prediction, is 5-4 to reverse, and go with the underlying trial court. Go with the trial court found all these burdens, found all these problems, and so reverse in light of the specific things of that thing. So that seems plausible. So yeah, I think Roberts, RBG, Sotomayor, Kagan, Breyer, majority. Yeah, that would be right. And then I don't know that Roberts necessarily wants to write this. I don't know. Maybe Kagan writes it. One of the nice benefits of being the Chief Justice is you get to decide who writes these cases if you're in the majority, which you would be in this situation. So yeah, I think that's Zach. That's definitely not how that works at all on any level. So yeah, I think that's the best possible probable. You might even see like someone else flip over on the fact specific thing. I think Alito's going to be in dissent. Thomas probably would. Kavanaugh and Gorsuch, though, I don't know really where they are going to wind up on this thing. I don't really have a super strong sense of where either of them are going to wind up. Yeah, it's I don't know where either of them are going to wind up. It could be really, really interesting. So that's pretty good. So that would be what I think is the best prediction. So I'm going to sign off now, but thank you very much for the 50 of you who are currently watching this. I really appreciate the stream, and I really appreciate everyone who's subscribed. I'm really getting to see a little bit of traction now, and I really appreciate that. And I hope you like the new setup. I hope you like the audio. I spent quite a bit of time yesterday massaging the audio to help reduce echo and things so that the audio quality would be better. So hopefully, the audio is really clean and you're enjoying that. So that's good. And we got the new setup, the new apartment. So that's all set up. Very exciting about that. And we'll see what's going on. 5K special? Maybe. We'll see. We'll see if we're going to do a 5K special. Yeah, possibly. So we'll see what's going on. So, we'll see. But until later, my friends, I hope all is well. Cheers and goodbye.